Let the record reflect that the jury seated, state's attorneys present, defendant, and defense counsel are present. At this time, I'd ask the foreperson, has the jury reached a verdict?
Your Honor, we have.
And is it the unanimous decision of all of the members of the jury?
Yes, Your Honor, it is.
Thank you, sir. You can hand it to the bailiff, please. Mr. Johnson, if you'll please rise. We, the jury, find the defendant, Romeo R. Johnson, a.k.a. Romeo Randolph Johnson, guilty of unlawful possession of a firearm by a felon as charged in the indictment. It's got the signature and the printed name of the foreperson. You may be seated. Does either party wish to have the jury polled?
The state does not. Yes, Your Honor.
So what that means, ladies and gentlemen, is I'm just going to go through and ask each one of you individually if this was your decision and your vote. And so I'm going to start on the top and go across and then come back around. So I'll start with the top. Ma'am, was this your individual verdict?
Yes.
Sir, was it yours?
Yes.
Ma'am, was it yours?
Yes.
Sir?
Yes.
Sir, was it yours? And sir?
Yes.
Ma'am, was it yours? And then we'll come down here. Sir, was this your individual verdict?
Yes.
Sir, was it yours?
Yes.
Sir, was it yours?
Yes.
And ma'am, was it yours?
Yes.
And sir, was it yours?
Yes.
All right, thank you very much. And what that means at this time is I will accept your verdict, and at this time find Mr. Johnson guilty of the offense of unlawful possession of a firearm by a felon. That means that the first phase of the trial is complete, and we'll move into the second phase, which is the punishment phase of the trial. And Mr. Coleman and Mr. Wilkerson, are y'all ready to proceed? Do you need just a short break?
State's ready to proceed. Defense ready, Your Honor.
All right, and so Mr. Coleman, if you will read the remainder of the indictment. Do you have it handy? Okay.
Said.
That's the enhancement paragraph. He'll need to plead true or not true to that.
And the grand jurors aforesaid, upon their oaths aforesaid, do further present in and to said court at said term that before the commission of the primary offense, the defendant was finally convicted of the felony of robbery second degree on March 9, 2015 in clause number 14-21127 in the criminal district court of Jefferson County, Texas, against the peace and dignity of the state.
And is that allegation true or not true?
True.
Okay, have a seat. Right.
That's your.
All right, let the record reflect state's attorneys present, defendant, and defense counsel are present. I've received a message that the jury has reached a verdict on punishment. You can bring the jury in. Let the record reflect the jury seated, state's attorneys present, defendant, and defense counsel are present. At this time, I'll ask the foreperson, has the jury reached a verdict on punishment?
Your Honor, we have.
And is it the unanimous decision of all of the members of the jury?
Yes, ma'am, Your Honor, it is.
Thank you, sir. You can hand it to the bailiff. Mr. Johnson, we, the jury, having found the defendant, Romeo R. Johnson, a.k.a. Romeo Randolph Johnson, guilty of the offense of unlawful possession of a firearm by a felon, find that the accusation of a prior conviction has been proved true. We assess the defendant's punishment at imprisonment in the Texas Department of Criminal Justice for a term of 15 years and no fine. You can have a seat. Does either party wish to have the jury polled?
State. No, Your Honor.
All right, thank you. And so is there any reason at this point not to pronounce sentence?
Not from state. Not from the defense.
Right, Mr. Johnson, then at this time, in conformity with the jury's verdict, I sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've already been in custody that the law gives you the right to receive. You can have a seat, sir. I've handed you two things already. The first is the trial court certification of your right to appeal. Obviously, this was not any type of agreement. You have a right to appeal. Mr. Wilkerson will talk to you about that. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you, obviously. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can also talk with Mr. Wilkerson. At this time, I'm going to remand you to the Jefferson County Sheriff's Department until transportation to the Texas Department of Criminal Justice. And ladies and gentlemen, at this time, what that means is that the case is over. I'm going to let them kind of get out of here for a second. I'm going to come visit with you informally just for a few minutes. You'll be released from your instructions that you were previously given. We all appreciate your time. Thank you, Mr. Coleman, Mr. Smith. Thank you, Mr. Wilson. And at this time, you can take Mr. Johnson to the back. And court will be in recess. If everyone would please excuse yourself from the courtroom. Good morning, sir. Are you Jeremiah Davis? And this is 250066, and Mr. Davis is charged with assault on a peace officer. And what is the announcement?
Your Honor, we're asking for a little more time. We have an offer on the case, and he wants to bring me some discovery that he thinks would help the prosecution.
Okay.
Make a different evaluation, and so I told him he needs to call me this week and make an appointment. He's called me before, but I think he's just been able to get this
Okay.
information.
Mr. Smith, any issue?
No.
All right, so Mr. Davis, I'll reset your case about 30 days. Make sure you get that done early on. Don't wait till the last minute before court so Mr. Parker can get what you have. He can get it to Mr. Smith, and then we can see where we get it the next court date. All right, you're free to go, sir. Mr. Shetley, in cause number 240776, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from October 22nd of 2022. And what that means is that if you go to trial and you're found guilty, the range of punishment would be a minimum 2 years up to 10 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 2-year deferred probation. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
That's correct.
All right, and Mr. Parker, you're hired, correct?
Yes, ma'am.
All right, Mr. Parker, we'll begin preparation for trial, and we'll get it set on the next available trial docket.
One thing, Judge, just, I think I have all the discovery that I need to confirm. In the discovery, it references a flash drive that was provided to the Groves Police Department. And I don't know if that's some of the discovery I have, or if there's actual flash drive that I need to get a hold of. And
Okay,
one other thing is the photos, if I can get it. Yeah, because the computer doesn't show it.
Okay, perfect. All right, thank you. Stay in touch with Mr. Parker. He'll tell you when you need to be back. Good morning, sir. You're Charles Young, and this is 250102, and you're charged with burglary of a habitation. And Mr. Wilkerson, what is the announcement?
Judge, we're going to ask, I'd like to request one more announcement setting. Still working on some information, and there's some additional information also that I need from the DA's office.
Okay. Has there been any issue with regard to bond conditions, Ms. Malfino?
No, Your Honor.
Well, if you recall, there was a hearing.
Yeah, that's what it
with regard to that matter. I'm still trying to get the evidence behind that hearing. So, in terms of what was alleged, like pictures, screenshots, messages, anything related to.
Uploaded all that discovery last week.
Okay, all right, sounds like it's all been
And a lot of
uploaded.
that, just so the court is aware, has come from the complainant calling the front desk, making reports for Nay, who then reports it to me. I just filed that motion, not to be punitive against the defendant, just to make sure the court was aware so that there could be a no contact for both of the parties either way. And everything that I have to be able to discuss.
Perfect. All right, so Mr. Young, I'm going to reset your case about 30 days. Make sure you stay in touch with Mr. Wilkerson so we can try to get an announcement at the next court date. All right, thank you, Mr. Wilkerson. Good morning, sir. Are you Shahram Omid?
Yes.
And this is 241684. Mr. Omid is charged with solicitation of prostitution, and it looks like there was an application for pretrial diversion.
Yes, Your Honor. We've
What's the
submitted that. We haven't got a return, Your
Okay.
Honor, but we are willing to set this case for a plea in the event it doesn't come back favorable to my client.
Okay, so what I'll do is one more reset. Mr. Smith, would you please get with, I guess, Mr. Canal or whoever is doing those up there, and if so, we can get an answer before that next court date.
Yes, ma'am.
That way you can get an answer. Either way, it'll get taken care of either
Yes,
with the
sir.
pretrial or with the plea on that next court
Thank
date.
you.
Thank you, sir. Stay in touch with your attorney. He'll let you know when you need to be back. And if it does get accepted, there will obviously be some other things where you'll need to go sign contracts and things like that. So if he gets accepted and the contract signing is after our next court date, y'all let me know. I'm not going to make you come, you don't have to come here.
Okay.
So we can reset it till after that to make sure all that gets taken place and
Yes, sir.
taken care of, okay?
Okay.
So just keep us, we'll set it for 30 days, but let me know where things
Make
stand.
notes.
Okay.
Thank you.
Thank you.
All right, you're free to go, sir. And sir, are you Celine Reinhardt? And will your client waive the formal reading of the indictment?
She will.
See, give me just a second. Ms. Reinhardt, you're charged with the second-degree felony offense of assault on a peace officer from December 22nd of 2024. And how do you plead to that charge? Oh, I'm sorry. Yeah, I see now. Hold on. Y'all are going on a lesser included, Class A.
Position arrest.
All right, so in 25-0089, the state has elected to proceed on the lesser included offense of a Class A misdemeanor resisting arrest from December 22nd of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Shalander? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And are you a U.S. citizen? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Reinhardt is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 1 year. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do all of that, then this is a great opportunity because you don't have a conviction on your record. And at the end of the probation, if you're successful, the case will be dismissed and you'll never have this conviction. The other side of that, though, is if you violate any condition of your probation, you can be brought back into court and you could be found guilty of the offense and sentenced to the Jefferson County Correctional Facility for a period of up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom, and the probation, she's at that desk right there. She's going to call you up in a few minutes to go over your paperwork. And you're going to help get that attachment?
Sarah's gonna email it to you.
Okay, thank you. All right, thank you.
Go ahead, I can do it.
That's between y'all. It's your job, but if he's going to do it, then it just has to be done today because once the case is closed out, you can't get to the portal. So
Okay.
that's why we need it, just so y'all make